All right. Good morning, everybody in the UK. Good afternoon, everyone in China, and good day, everyone in between. I'm delighted to welcome you this morning to our CVVC webinar on China patents, registration and enforcement strategies for business. Our two presenters today are Peter Arrowsmith, partner at Cleveland, and Wenping Chen, partner at King & Wood Mallesons. Peter will be joining us from the UK, and Wenping will be joining us from China. So before we get going, just a few little bits and pieces about CVVC and about this webinar platform. The China-Britain Business Council is the leading organisation helping UK companies grow and develop their business with China. CVVC supports British companies of all sizes and at every stage of market entry with practical in-market assistance, services, industry initiatives, as well as a membership program offering access, seminars and significant networking. CVVC works closely with UKTI and the FCO and has a strategic partnership with the British Chamber of Commerce in Beijing, providing corporate members with reciprocal membership. Our business ed board and professional team have extensive first-hand experience of doing business in China, and through 60 years of engagement, CVVC has built up exceptional connections with government and business across China. CVVC services are delivered through a network of 10 offices in the UK and 13 strategic locations across China. CVVC helps companies to network and learn from China-savvy multinationals and SMEs to understand the intricacies of doing business in China and to develop sound strategies for expanding in the fast-changing and dynamic place that is modern China. So that's just a little bit of background on ourselves. You can see the coverage that we have throughout China and throughout the UK, so please feel free to contact us, and we will continue hopefully to expand and grow and develop our business both sides here and in China. So this is a relatively interactive platform. If you have questions, please do ask them. I am highlighting, hopefully in a second, the little area that you would just ask a question. If your question is relevant and pertinent to the flow of the presenter at that time, I'll just drop it in at that moment. Otherwise, we'll save it to the end. And if we don't get to it, I'll pass it on to the speakers who will follow up afterwards. If I could ask you, please, to click on the Raise Your Hand button, the area that I'm highlighting now. That will just make me feel a little bit confident that I'm not speaking out to the ether and that there are actually some people out there listening to me. All right, fantastic. So everybody has raised their hand, so I can assume that everything is going along okay. All right, if you have any questions, as I say, be they technical or be they for the content matter today, please just drop them in there and I will endeavour to answer them for you. Right, moving along to our speakers. So Peter Arrowsmith is a partner at Cleveland, a firm of patent and trademark attorneys with offices in London and Reading. He's a chartered and European patent attorney. Scientific background in physics, Peter deals with inventions across a range of technology. Peter is an active member of the IP community in the UK, and he is a regular speaker and author on current issues relating to patents and registered designs. Peter also takes a keen interest in issues relating to Chinese IP and is a regular visitor to China. Our second speaker today is Wenping Chen. He's a partner of King & Wood Mallesons. He's team leader of the Chemical Pharma Biotech Patent Group at King & Wood Mallesons, advising and prosecuting patent applications in China for foreign and domestic companies, advising and representing clients before the PRC Patent Office for patent invalidation cases, advising and representing clients before PRC courts for patent infringement and patent invalidation cases, advising and dealing with cross-border patent litigation, including 337 cases before ITC, managing and conducting FTO research and analysis, IP due diligence in mergers and acquisitions. All right, terrific. So there are two presenters today. I think you can say that they're experts in their field. So before we begin, before I hand over, as I said, these are a relatively interactive platform that we have here. So we like to drop in questions just to see what you're thinking and see what's going on. So the first one I'm going to ask is just very simply, where are you? So I've launched that now, so you should be able to see on your screen. If you could just click, please, on wherever you are. And also, if you could click Submit at the bottom, that would be fantastic. So I can see now that almost everybody, just give it another couple of seconds. Another couple of seconds, very good. That basically makes the point. So there will be quite a few more of these throughout the presentation. So I can share the results with you. And for those of you familiar with our webinars, I'm pleased to see that 60% of people are UK outside of London. Basically, the main reason that we do these webinars is to enable people who mightn't ordinarily be able to, maybe come to our office for such a presentation to also get the content and advice and support that they need. All right, I'm going to hide that, and now I'm going to hand over, if I can. Let me just jump in here. This is my Houston, are you out there kind of moment. I'll just jump in and see Peter Arrowsmith. Are you out there?
I'm there, David.
Brilliant. Okay, well, I think your slide is up, so when you want me to change the slides, just please say next slide, please.
Well, thank you very much, David, for that excellent introduction, and hello to everyone out there. So my name is Peter Arrowsmith, and I'm a patent attorney at Cleveland. As David mentioned, we have offices in London and Reading, and we give advice on patents, trademarks, and designs. So in terms of the structure of this talk, I mean, I'm obviously a UK European patent attorney, so my experience is in helping UK companies to get protection everywhere in the world, including China. So I'm going to give a bit of perspective from the UK side in terms of acquiring patents and strategies that you should think about. And then I'll pass on to Chen Wenping, who is, as David mentions, a Chinese IP specialist. And Wenping will give some perspective from a Chinese perspective, talking about issues post-grant, so after you've already got your patent and you're interested in enforcement. So next slide, please, David. So to start with, I'm not sure at the moment what your backgrounds are, so I thought I'd give a very brief introduction to different types of IP, just to dispel a few myths. So there are various different types of intellectual property, both in the UK and in China, and they include trademarks. So if we look at the image on the right, we see these well-known vacuum cleaners, which are a client of ours called Pneumatic. So the names on there, Hetty, Henry, are trademarks. So they are words that give you an indication of the origin of those goods, and they're protected so that no one else can use those names or similar names for similar products. Copyright protects aesthetic creations. So here we're looking at a photograph on the right. That photograph would qualify for copyright protection, so anyone who copied that photograph would infringe the copyright. Copyright, of course, also extends to literary creations, and sculptures, musical creations, and things like that. Designs protect the way that things look, so the look of those vacuum cleaners with their distinctive top hats could be protected by designs both in the UK and China. Know-how is an unregistered form of intellectual property, but effectively it protects people. So, you know, the people who make these vacuum cleaners will understand what you need to do to put those vacuum cleaners together, and just by having those people in-house and having that expertise, that's a form of intellectual property. Commercial secrets, again, it's an unregistered form of protection, but a commercial secret can only really protect a method. So if you have a method or a process for doing something, just by keeping that secret within your own company, you can protect it. Of course, it doesn't work for product, because once you've sold it, that's out there in the world. So the only way to protect a product invention is through a patent. So patents in the UK and in China are intended for protecting inventions. There is another option in China which doesn't exist in the UK, which is called a utility model, and I'll come on to that later. So next slide, please, David. So a quick poll.
Yep, I'll launch a quick poll now. Let me just find it here. Here we go. So it's just for Peter to understand a little bit more about who's joined us today. Just where have you filed patents? UK only, China only, UK and China neither. So just to give a sense of who you all are out there, basically. Just give it another couple of seconds. Nearly there. About 3/4 of you have now clicked in. So I think you'll see that we have a relatively experienced bunch here today, Peter, once I close this off. But still a few who have done neither. So I will close that and I will share the results. So 15% UK only, 0% China only, 55% UK and China, and 30% neither.
Okay, well, the 30% neither, that background was for you. Everybody else are kind of experts, so that's encouraging. Okay, so for Chinese patents, the basic principles of protection in China are the same as those in the UK, so this will be familiar to most of you. So a patentable invention in China, as in the UK, must be new, it must be inventive, it must be capable of industrial application, and it must not be excluded. So in terms of novelty, the way that works, as many of you may understand, is from the date that you file a patent application, you look backwards in history and you ask, is this invention different from everything which is known to the public before that date? And that includes all previous patent applications, it includes anything that's been published on the internet, and crucially, both in China and in the UK, it includes anything that you have said or done yourself. So when I refer on the slide to absolute novelty, that's what that means. It means that absolutely everything that you have done is relevant to the patentability of your invention. So it's equally important in China, just as it is in the UK, to be very careful not to disclose or describe your invention before you file a patent application. Of course, to be inventive, your invention needs to solve some kind of problem, it needs to produce some kind of advantage, just in almost the same way in China as it does in the UK. So it also must not be excluded. So David, if we go to the next slide, I've put up some excluded categories. So I won't go through these in detail, I'll let you look at them. The purpose of this slide is really to point out that the exclusions in China are very similar to the exclusions in Europe. There are some differences which patent attorneys and IP solicitors very much enjoy talking about and pontificating about, but in terms of fundamentals, there are many, many similarities. So just taking one example, computer programs is a well-known area in which it's difficult to get patents in the UK and Europe. The same is true in China, but equally in China, if your invention produces some kind of technical improvement, then it may be patentable, even if it relates to a computer program. So many computer programs in the UK and Europe are patentable because they produce some kind of technical advantage, they control a machine, and that makes them patentable. The same is true in China. So that's just to give you a flavor of the exclusions in China. Okay, David? Next slide. Okay, so the Chinese patent application, so the principle or the process for applying is to file a patent application in Chinese at the State Intellectual Property Office. That patent application is then examined rigorously to check that it meets the requirements for patentability in just the same way as it is in the UK or at the European Patent Office. Typical processing time at the SIPO is 2 to 4 years, or perhaps a little bit longer, which actually compares fairly well in comparison with other patent offices around the world. Once your patent is granted, it lasts for 20 years from the date of filing, and of course you can file in China through the PCT or International Application System. So a typical strategy for a UK company would be to file a UK patent application first, get the UK IPO to do a search so that you can find out whether or not your invention is likely to meet the requirements of novelty and inventive step, and then 12 months later file foreign applications, including a Chinese application if you want to have protection in China, or you could file a PCT or international application and then enter the Chinese phase later. So do you need a Chinese patent application? Well, what I always say to my clients is think about how damaging it would be to you if someone began using your invention in China. So in general, I would recommend that people file patent applications in countries that are most economically important to them. So where are your sales? Where are your competitors? You know, where would an infringement hurt you? And try and file patent applications in those countries. But at the same time, try and minimize that list, because cost of the patent application process scales linearly with the number of countries in which you file. So there's no point in filing a Chinese patent application if you have no business in China and you don't believe that you will have any business in China. I would only recommend it if you can see an economic advantage to you. Okay, next slide please, David. Okay, so utility models are an interesting feature from a UK perspective because they don't exist in the UK, and therefore they represent an alternative option to a patent in China. So a utility model is like a short-term patent. They don't exist only in China. Many other countries have them as well, most notably Germany, which uses them to great effect. So they only last for 10 years in comparison to the 20 years of patents. The requirements for protection are almost the same as patents, so it must be new, it must be incapable of industrial application, it can't be excluded, but there's a very slightly lower threshold of inventive step than applies for patents. As I mentioned, there's no corresponding right in the UK, and importantly, utility models only apply for inventions that relate to the shape or structure of a product. So you can't get a utility model for everything that you could get a patent for. So a good example would be a method. So if you have a new industrial method which is more efficient, which is inventive, which would, be entirely appropriate subject matter for a patent, that could not be granted a utility model in China. And in fact, the SIPO have become much more strict in identifying those type of inventions and refusing utility models for them.
Peter, a quick question. I have a question here from Will. You may have just answered it, but he asks specifically about utility models. Is this similar to registered design, which can be applied for in the UK?
It's between a registered design and a patent. So there are registered designs also in China. Registered designs protect the way that things look. Utility models protect the way that things work. So a registered design doesn't, if there's a functional aspect to a design, that is not protected with a registered design in the UK or Europe. Utility models, on the other hand, protect functional, inventive aspects of a product. So I hope that that answers that. Of course, if there are any other questions, please carry on to ask them, and maybe we can come to them at the end. So in terms of the way that they look, utility model applications look the same as patent applications. There's a description, there are claims, you file it at the SIPO, but very importantly, they're not examined for novelty and inventive step. So you just file it, and provided it meets the formal requirements for in terms of not relating to a shape or structure of a product, and the claims are clear, then the utility model will be granted, even if actually it's not new or inventive. And the reason that the SIPO does that is to make it a cheaper option, so that it's much cheaper to get a utility model granted than a patent, just because it's not examined. And those who have experience of the patent application process will know that there's a to and fro in the patent application where you try and negotiate the scope of claims that would be allowed. That doesn't happen with utility models, which means that they can be granted much quicker and much cheaper. So one option that you can use is to file a utility model and a patent application in parallel. So you get granted the utility model quickly and cheaply, and then the patent application could be granted later, and you could allow the patent application to take the place of the utility model once it's granted. So next slide, please, David.
Quick question here from David. I'm conscious of time, that we don't go too slowly at the start, but it's a fair point. Any thoughts on the actual cost of utility model filing and that process, perhaps in comparison to normal patent filing?
So I think if you go to the next slide.
Oh, huzzah. I probably should have checked. Here we go.
Here we are. So I hope that that's a useful comparison. Just to answer that question directly, I've said in the slide that the cost is lower for utility models and it's higher for patents. I mean, it's very difficult to give an overall cost for applying for a patent in China, because it does depend on the number and nature of objections that you receive. Of course, it depends on the length of the specification, because you've got to translate that into Chinese. But utility model would be very much cheaper than a patent. You may be talking to 25% or something like that over the course of the application. So one aspect of utility models that I don't want to get drawn into too much, but which has drawn a lot of press, are the junk utility models. So although utility models seem attractive, because they're not examined. That also provides an opportunity for unscrupulous operators. So what's possible would be to file a utility model application based on an existing product of a foreign company. So in normal circumstances, utility models applications like that would be granted, even though the invention is not new and even though the foreign company has an existing product on the market. So in the very worst cases, these utility models are actually asserted against the foreign company that originally developed the product, essentially in an attempt to secure a license fee or to create trouble. So this is a bit of a problem in the Chinese system, and the SIPO are very much aware of it and are taking steps to prevent it. So they've introduced some new guidelines to encourage examiners to conduct a preliminary search to try and find out if the utility model is obviously not new, and those are still bedding in, but the shift in practice is clearly intended to weed out those applications that plagiarize existing products. So, I mean, of course, this is a real minority of utility model applications, but nevertheless it's a problem which is inherent with a system that doesn't examine for novelty and inventive step. Okay, let's go to the next slide. We've got a quick poll here.
Okay, yeah, we got another quick poll. Let's drop that in. It is, what proportion of Chinese, hang on, let's share this. What proportion of Chinese utility models are done by foreign companies? So that has hopefully been launched now, and that should be on all of your screens. If you can just, this is one of those sort of do you know quick
well,
fact.
have a guess. It's
yeah.
Nobody will know, but have a guess.
Oh, I'll know. So we're nearly there. Just give it another couple of seconds. Quick question came just while we're waiting for that. How does what you were just talking about beforehand? How does it work in Germany? Somebody, Andy dropped in. While we're waiting for that to come through.
Well, they have similar problems. I mean, it's a problem which is inherent in a utility model system. I think it's less of a problem in Germany. I think that the courts, it's much easier to get rid of those type of problems in the courts in Germany. They're much less ready to consider them. So it's a problem that you have in a system that doesn't examine for novelty and inventive step.
Fair enough. Okay, our results here, 18% say less than 1%, 55% say 1 to 10, 23 say 10 to 50, and 5% say more than 50. Would you like to reveal the answer for us?
Well, the answer is less than 1, and I think a lot of people have, are going towards the right direction with 1 to 10%. I mean, I find that really interesting that less than 1% of utility models are filed by foreign companies, and really I think what that demonstrates is the success of the system from the Chinese perspective. So it's been really adopted with gusto by Chinese companies. They see it as a great way to get low-cost protection, and foreign companies, partly because there are no utility models rather in the UK, in the US, are perhaps less ready to adopt them just because they're less familiar with them. I would say that utility models should be considered as another way for possibly protecting the right kind of invention in China. So I just have 2 more quick slides before we hand over to Wenping. There are important things to think about if you do R&D in China. So if the invention is made in China, then you have an obligation to file your patent application first in China. So it is in fact a criminal offense to file a patent application outside of China if the invention was developed by a Chinese national in China, if that means that a state secret is divulged. So I would recommend strongly that care is taken not to violate that requirement. That's also in fact a ground for invalidity. So even if you don't divulge a state secret, then the fact that you didn't file in China first could be used to invalidate your Chinese patent. You also need to make sure in China that you have a scheme for properly compensating inventors who are Chinese employees. The Chinese law on this point is much more specific than UK law is, so you would need to take advice from a firm of solicitors to make sure that you don't fall foul of that requirement as well. Okay, David? And now just a quick word on Hong Kong and Macau. So Chinese patents and indeed utility models do not apply in Hong Kong or Macau, or of course in Taiwan, which has its own system. In Hong Kong, if you want protection, then you can piggyback your patent application on a European patent, which designates the UK, a UK patent, or a Chinese patent application. So you effectively register the fact that you have one of those parent applications, and then once that parent application grants, your Hong Kong application would grant as well. So there's no separate examination in Hong Kong. I would question whether you really need patent protection in Hong Kong and Macau. Again, you need to think about cost benefit. Hong Kong and Macau are very small, but for the right type of product, protection in those countries could be important. So there is also a short-term patent that you can get in Hong Kong, which is an alternative to the standard patent application. That lasts only for 8 years, but it's not a utility model. It's a very rarely used property because most UK companies would use the standard application and piggyback. In Macau, you can get a patent application and a utility model application, but you need to file those directly in Macau. There's no piggyback system. So that's a very brief, very broad overview of strategies for obtaining patent protection and utility model protection in China. So with that, I will hand over to Chen Wenping, who hopefully will provide us with some strategies for enforcing those patents.
Okay, thanks very much. Let me just see if Chen is out there. He hopefully is. Peter, I'm going to put you on mute. Thanks very much. We'll bring you back for the questions and answers bit at the end. And Chen Wenping, are you there?
Yes.
Brilliant.
Okay. Thank you, Peter. That's for the clear and the great presentation about the obtaining the patent in China. I'll cover more on the enforcement side and about the patent enforcement, and maybe a little bit covering on the other IP rights also. Okay. First of all, I would like to have some word about the firm and also a clarification on my introduction. My bio. So in the introduction for myself, there's a sentence that it's I'm covering the cross-border patent litigation, including 337 cases before the ITC. That means that the number the patent cases are handled before the ITC, 337. Rather, it's a law of name of in the U.S. It's a section 337 that's covering the importing technology products into the U.S. And involving the patent issues. So that's a clarification. And so the firm it's a general purpose law firm, and dealing with every aspect of the law, and the partner responsible for the patent issues, and the tech and background is chemical, pharmaceutical, and the biotechnology. So I do both the prosecution and also the litigation. So that's why I cover the enforcement side. So the slides here cover the litigation in China, and so general introduction about the enforcement side. So next slide, David. The enforcement of patent rights here is quite unique and quite different from other countries in that we have two roads to enforce patent rights. One is the administrative road, and another is judicial road before the court. Next slide, please. David? Yes. This chart shows the venue, the organization or the agency or government agency dealing with the enforcement of patent different IP rights. Corresponding to Peter's presentation, that it's different types of IP rights. You have trademark, trade secret. You have patent rights. You have copyright. So different types of IP rights having different organizations and government agencies to handle the enforcement rights. So for the patent rights, we have the local intellectual property office to handle the enforcement of the patent rights by the administration way. So, but it's less popular, and more patent owners choose to use the court system instead of the administrative organizations. Partially because the patent issues are more complicated and they more relates to the technical issues, technology, appraisals, and the different laws procedures. And the administrative road is the benefits is on and it's fairly quick, and you get it's to have a straightforward case, and you get result in a reasonable period of time. That's, for example, several months. So, but for complicated cases, so it's not necessarily the case. So people go to the court instead. So next slide, please. Yeah, the court system here, we have centralized judicial system, have about 4 levels of court. From the bottom is the district court, and then intermediate court, high court, and Supreme Court. And most of the cases, the patent cases go from the intermediate court. So and there are many intermediate courts, but there's only a limited number of the courts have the jurisdiction over the patent cases, and they in different provinces they have their own court dealing the cases. So where to sue depends on different levels and different the places where the defendant resides or the infringement happens. So next slide, please, David. And here is a chart showing the timing and also the main procedures before the court, before from the filing the complaint to exchange of evidence and the hearing, and to the court ruling, the decision, and the appeal. So for each instance, it lasts about 1 year. Of course, this can be longer. It can be 2 years or 3 years, but typically it takes 1 year. Next slide. Yeah, next one. So I used one case I handled. That's it's quite old case, but it's relates to different aspects of the court system here, and it's the patentee is it's a Japanese agrochemical company, and the defendant is a local competitor producing the same herbicide in Jiangsu province. And we used the circuit to two patents. One is related to the process for making the active ingredient of the product, and another patent relates to the composition as the end product of the herbicide. We won the case, finding the infringement on the both patents. And next slide. And also we have the damage awarded and the injunction awarded and excluded. So that's the basic information of the case, and I have the so next slide. So when we talk about the different aspects of litigation, we'll also talk about the case. So first thing is we're to sue. So there's many patents, as I showed in the earlier slide. So there are over 400 in court, and we go for patent case. We go from in court, but it's still centralized to about 60 courts having the jurisdiction over the patent issues. And in our case, we sue the defendant in Nanjing Intermediate Court and appeal to the Jiangsu High Court. And the venue of the litigation depends on where the defendant resides or the infringement occurs. Next slide. And David, next one, yes. So here you have many choices, and China is big country, and the different courts have different experience in IP issues, especially patent issues. And in some specific issues, they may have different opinions, so you have to make the forum shopping to choose a favorable court to sue. So it's possible because you can sue either where the manufacturer resides or where the product is found for selling. So if you sue the manufacturer outside of the home jurisdiction, so you have to sue a distributor usually together with the manufacturer, sue them as the co-defendant, and so that's the possible. But in our case, in a case study, we have no choice because the product was sold to other countries, and we get the evidence in a foreign country, and in China there's no dispute on the same product, and so we have to sue them in a home jurisdiction in Nanjing. But the interesting thing is that in Nanjing, Japanese people is not welcome because of the history of the Second World War, but still we have to do that because that's the only place we can sue in that case. But unfortunately, we got the favorable the judgment in the end of the case. Next slides, please.
Chan, just a question. Yeah. I mean, a quick question. Actually, the point you raised about Nanjing and Japan and all of that kind of stuff. Are you saying there that you would feel in any way nervous about different courts, or you don't think that it's a black and white rule of law thing, that there might be other influences on decisions, or has that made progress? Because I think there is a sort of a reputation out there sometimes about the rule of law. So how would you comment on that?
Yeah, of course, there's theoretically there shouldn't be no effects from other the factors. It's based on the law and the facts. But in fact, as in other countries, it's the judge is a human, and they may have to be affected by psychology, by other factors, and they even for the patentee, if they are Japanese, the first reaction is they will refuse, not willing to go to the Nanjing city, either it's affected at any time or not. But it's the first choice is not in Nanjing for the Japanese people. Okay.
Sure. No, I fully understand. Having lived there for a number of years, I get the gig. But it's just interesting that these things, you have to be cautious, and I suppose you have to be streetwise and box smart. We have launched a poll there. Which city do you think will have special courts? So is it Beijing, Shanghai, Guangzhou, or all three cities? If you could just click on the one.
Yeah, it's a new thing. Just you just guess, because there's just the Chinese government decided to have a specialized IP court. Right now we don't have the specialized IP court. It's the court dealing with the patent case, also deal with the criminal cases, other civil cases. The government right now decided to have the specialized IP cases and in some cities, and so just a guess which city will get the
all right.
Specialized IP rights.
Well, I think just over nearly 80% have done their click, so I'll close that and I'll share the results. 5% Beijing, 25% say Shanghai, 5% say Guangzhou, and 65% say all three. So, Chen, will you reveal the great mystery?
Yeah, as you think the audience have the good guess as all the three cities will have this IP specialized IP code, because the 30 cities traditionally are mostly popular places where the patent cases are filed. So especially in Beijing, that's the highest number of the patent cases. The Beijing court handled both the infringement cases and also the administrative cases against the patent validity decisions. So, so what happened after the filing? Usually, in our case, though, of course, the defendant filed as a defense filed the patent validation request before the patent examination board, and they also filed a reply, and also the court held a preliminary hearing about the evidence, and then have a formal trial, and at the end of time get the final judgment. So that's basically the procedure. Next slide. So since the court in China dealing with the patent infringement cases, they will not handle not trial the validity issue. The validity will be handled by another the forum, that is Patent Reexamination Board under the CIPO. We call the PRB. So once the invalidation proceeding is initiated, so the court handling the infringement case will consider whether the proceeding is stayed or not. Generally, that depends on whether the patent is patent for invention, the regular patent, or patent for utility model design. So, since, as Peter discussed, for the utility model design, there's no substantive examination. It's kind of a registration, and it's more likely to be invalidated. So, for that kind of the patent, so if it's filed a litigation, the court and the defendant filed the invalidation action against the utility model, and the court may more likely stay the proceeding of the infringement case. And of course, the court will look at the other factors, whether the evidence is sufficiently or is serious or not. Next slide. David, next slide, please. And in addition to the invalidity challenge, there are other defenses for non-infringement. But of course, if you're not infringing, that means you do not cover the product or process, do not cover all the technical features in the claim. So that's you're not infringing, or you just practicing in prior. It's in prior, but it's still covered by the patent. That's like Peter mentioned that for your model, it's quite possible that it's not really new, but still it's granted as patent. But in that case, you can choose to attack the validity of the utility model, or just you find a piece of prior, let's say, documents published before the patent filing date, and it's patent code that you are using the technology that's published before the patent filing date. So the court can find non-infringement strictly instead of waiting the decision before the PRB about the validity of the patent. You have the non-commercial use that private and individual use for the family. Usually is not infringing. And the exhaustion of patent rights, that's the products produced by the by the patent owner or the licensee of the patent owner, and the subsequent use or sales of the same product that were not infringing. And the prior use right is important, maybe again for the utility models. So prior use means that before the final date, you have to start to use the technology, have produced the product. Usually that's applicable to the process patent, because you started to use that process in-house, but it's not published to the public, and it's still new, and it can be filed as a patent. And if you do not file the patent, but a third party filed a patent over the same technology, so you may be blocked by the subsequent filed the patent right. And if you have the evidence showing that your use is earlier than the filing date of the third party's patent, you can defend as a non-infringing. But it's limited because the law says you cannot expand your scale of the production, and you can keep the use of the technology in the original scale. And the scientific research and experimentation is not infringing. And another exception that is not listed here is for pharmaceutical, that's regulatory exception, as we call it, the board exception, similar to the U.S. practice. Since that for pharmaceutical product, you have to make the research and the clinical trials and get the approval by the government. So all these activities for getting the approval, if it is covered by the patent, it's non-infringing according to law. That's the exception for infringement. So statutory of limitations, we have 2 years of statutory limitation. So you have to file a lawsuit once in 2 years from your knowledge of the existence of the infringement. And so after that, you may have lose your right or have the lost your limit your claim of damage to 2 years before the final date of the lawsuit. So next slide, please. For the time limiting, we'll quickly go through other slides. About the evidence collection, the important thing is that we are not a common law country, so we don't have law discovery procedure. So parties have to collect the evidence by their own, but still have the some means to ask the court to get help. That's what we call the evidence preservation. That's some evidence to be lost, or you cannot get access, and you can apply the court to get the collection of the relevant evidence either from the some government authority, from tax authority, from the customs, or from the evidence the premises. Next slide. Next slide is about the remedies when you won the case, and you can get remedies of the injunction. Right now, it's kind of automatic way. If you won the case, there's the infringement is found, you can get an injunction as well as the invention and the patent is still valid by the time of infringement. The decision is made. And for the damage is not so high. Traditionally, because of the difficulty to get the evidence proving the either the patentee's losses or the infringer's profits made by the infringement. But if you have the existing license agreement, and the damage can be based on the royalty provided in the license agreement, as 1 to 3 times of the royalty. And finally, if you don't have any evidence about the number of the damages, you just claim a number between 10,000 RMB to 1 million RMB. Next slide, please. So utility model is special in China, and but the enforcement side is practically the same, except that the patent evaluation report from the sample is required before filing the lawsuit based on the utility model. So the other aspects are the same. It's not because we support utility model and they can get the lower damage. It's not the case. It's as long as it's infringing, and you can proving the number of damages, you can get that. So one thing that is that you have the cases where the foreign company having the partners here, local partners for either distribution or the some manufacturer, and the Chinese partners can use your technology to file the utility model. And so maybe later you yourself can be prevented from using the technology because of the utility model that they filed by a third party. So it's important to make the non-disclosure agreement beforehand, before you deliver any confidential part of the information to any party, even if it is a partner. And you have to preserve your prior use evidence. So in case there's any litigation against it, based on the utility model filed by other parties. Okay, the next is remaining slides relates to the patent invalidity. Next slide, please, David. About the patent invalidation. That's the important part about the patent system. And in most cases, if you have the evidence, having good cases before the court in proving the infringement, but the case is that whether the patent is valid or not. And so, as I mentioned earlier, the court will not decide the validity of the patent, and you have to go to the PRB. The PRB will trial the validity. But for the validity action, so any party, any person can file that against a patent at any time after the patent is granted. There's a broad range of the grants. Almost all the grants as required for the granting can be as the grants for invalidation. So the threshold for filing the case is quite low. So next slide, please. The procedure of patent validation quite similar to the about like the case before the court. So you file the action, and then the patentee have the reply, and then have the second round of exchange of paper, and have a hearing, and then have the decision. The one thing you have to know is that as a patentee, you have much pressure in such action because the reply time limit is very limited. It's 1 month from receipt of the notice, and you have to prepare out the full response to the to each grounds of the invalidation raised by the petitioner, and you have to collect all the evidence supporting your case. So it's quite demanding. And the decision of the PRB, the Patent Validation Board, can be appealed to the court. There's only one court have the jurisdiction over such cases as Beijing No. 1 Intermediate Court. That is for the first instance. And the Beijing Intermediate Court's decision can be appealed to the Beijing High Court. Beijing High Court have the final decision as binding decision about the validity of a patent. Next slide, please. Here's a case about the validity of the case of a patent. There are two aspects of the same patent. One relates to the protein, and another relates to the nucleic acid for coding the same protein. But the one claim, the protein claim is maintained as valid, but the nucleic acid claim is found invalid. The reason is that the specification just disclosed the data supporting the anti-tumor activities of the protein, but not for the nucleic acid. So that's now the case is telling that it's in China, it's the data verifying the activity is very important, especially for the chemical pharmaceutical related innovations. You have to provide that data in the specification. You cannot just provide that later after filing during the prosecution. You have to make the case credible in the specification itself. Next slide. So that's the a poll about the patents that can survive from the patent invalidation challenge.
Yeah, so here's just another poll. How likely is a patent to be invalidated? So please just click on your answer. In terms of questions, I mean, a lot of questions, and Peter, I'll bring you in on this in the end. It seems to be a lot of people are asking kind of what's the point of the utility model part. I mean, I think maybe because we don't have it here in the UK, some people are questioning its relevance. Would you like to comment on that?
Is it for me?
Yeah, I mean for you
okay.
first, Chen, and we can bring Peter in because we're basically at the end.
Yeah, the utility model is, as Peter said, is used by the local companies very often. You have the low threat of getting the patent, and it's get quick. You can get the patent granted less than 1 year, and you can enforce that. And it's very convenient for the companies get patent protection. The main reasons getting utility model is that you have for some products the marketing life is quite limited, and if you follow the regular the patent for invention and it go to the substantive examination, that takes several years when you get a patent, and you have not many years for protection left. And so the utility model is provided as the quick protection, but it depends on yourself on the drafted the proper claim, let it be subject to the challenge later. So
sure. Okay. I mean, I'll ping that across to Peter in a second, but just there's the result of your question there. 0% less than 20, 56, 20 to 40, 38, 40 to 60, and 6%, 60 to 80. Have you? Can you reveal the answer there for us as well?
Yes, I think the answer is that about 50% is 40 to 60% will survive from the patentability challenge, and it's yeah, about half. But another interesting number is that when you get the decision from PRB and you have to appeal to the court, but the successful chance of appeal to the court is quite low. It's less than 10%. So that means that if you won the case before the PRB and you won the case all over the proceeding, if you lose that and you can get that overruled, it's very rare.
Okay. Thank you for that. As you can see, I've moved on to the Q&A slide there. Please do drop in a question. Thank you very much, Chen. And what I'm going to do is I'm going to bring Peter. I'm going to unmute you. Peter, I've had, a lot of the questions that I've had through have been on the theme of kind of, I'm being a non-expert here, but sort of what's the deal with these utility model things? Is there really a point to it? Chen just gave us a comment there. Would you like to comment on that as well?
There are two advantages to utility model: cost and speed. So if money's no object and time is no object, then you would apply for a patent application. But utility models are significantly cheaper and you get them granted significantly faster. So if you are thinking, well, I sort of need I could maybe do with some protection in China, but it's maybe not worth filing a patent application, it's not worth the money, then I would say, well, think about filing a utility model because the cost is significantly cheaper. You get some form of protection in China. As long as you believe that your invention is new and inventive, then you can establish validity if you need to enforce it. As Chen has explained, utility models can be enforced in China, so it's something rather than nothing for much less cost than a patent application.
All right. I'm a little conscious of time. We've gone on quite long today, and I've sort of bundled some of the questions in at different points. One final question, if I could find it, in terms of utility models again. In terms of demonstrating a difference, if you are making a challenge, is there any kind of rule of thumb for how much difference you need to demonstrate? Again, I'm speaking as a non-expert here, but Peter, do you know where I'm coming from?
The utility model needs to be new and it needs to involve an inventive step. So invalidating a utility model would be the same process as invalidating a patent. You'd need to find, do a search, what's been done that's related to this invention before it was filed, and does the invention really involve any difference? So that's the process that you would need to go through. I'm not sure if that helps or not.
Yeah, I think it does. I'd say I'm sort of paraphrasing. I've one final question here. Is there an economic middle way for SME clients, e.g. UK client has utility model registered in China, Chinese company infringes it, sells abroad, etc. Is there some legal service where can send Chinese infringer letters demonstrating the Chinese side will lose out by continuing to infringe and have good practical chance of making them back down and stop infringement, i.e. avoiding court case costs but spending money on effective forms of legal communication alone?
Well, I think this would be Wenping's
over to you, Wenping.
Yes, I think the system is there, and they actually we have the other interest numbers. That is, the enforcement system is used mostly by the local companies. That over 90% of the cases are among the domestic companies, and the foreign-related cases are very limited. But it's so the system is there, and and depends on how to use that, and is used every aspect of the system of litigation. And we do have the cases representing the foreign companies winning the cases and executing their judgment and get the production stopped and the money collected. So it's it's not straightforward. It's have to take the efforts even after you get the judgment of the winning case, and it's not automatically executed, and you have to take the efforts and to deal with the court to make the compulsory the enforcement or the execution of the judgment. So that's another session of the litigation. So it's there, and it can be enforced, but still you need put the energy to the efforts.
But in terms of, I guess, what the person is getting at, in terms of trying to avoid going to actually going to court, are there any top tips maybe for? He suggests SMEs. I mean, I think he means companies without wads of cash, basically.
Can I just step in very, very briefly? I mean, just all I would say is, if you have an issue where there is an infringement, then of course the objective is to avoid going to court. That's
Sure.
true in the UK, it's true in China, and it's about everything that you do is about trying to avoid going to court. So of course you do what you can, but if you're going to start talking to an infringer in China, then you need to be prepared to go to court, because ultimately that is the only way that you can actually enforce your patent.
Fair enough. Thank you. Final question. Do courts in any particular region, this is from John, do courts in any particular region give higher damages, or is it pretty consistent across the country?
The highest damage awarded right now, I think, is in Zhejiang province. The Zhejiang High Court got the number interestingly based on the utility model.
Okay, but generally speaking, the awards are consistent. Would that be fair to say across different jurisdictions or different areas?
Yes, quite. It's fairly it's not so high, and it's similar all over the country.
All right, thank you. I'm going to say to Peter and to Peter R. Smith and to Chen Wenping, thank you very much for your time and your expertise today. I think we'll wrap it up there. If you have any other questions, please feel free to contact me or to Peter and Wenping directly. I'm happy to facilitate that discussion if you need that. Just to give you a little bit of other bits and pieces, if you like these webinars, we record them and we rebroadcast them. You can go onto our webpage, What Do We Do? You'll find webinars there. So if you feel that maybe there was a colleague or friend who should have seen it, or you want to kind of have another go to digest it all, please do go to our website and have a look there. We also put it onto our YouTube channel just to help people get this information a second time around. Upcoming events in the UK, CVBC is an incredibly busy organization. I've just taken a quick week ahead snapshot basically of what we've got coming up. In Aberdeen, there is a lunch with the Consul General, Pan Xin Chun up there. Then in London on the 11th, we have pro-deal and post-default considerations for maximizing Chinese investments. So that will be in our office in London. Also on the 11th in Liverpool, doing business in China, market opportunities. And on the 16th in Birmingham, we have our SME China Forum. So just to give an example of all over the UK, we're doing events. Please go to our website and have a look at our events calendar to see specifics. In China, we also have our CVBC China Outbound series. There's a lot of focus from CVBC on outbound investment from China into the UK, and a lot of events and a lot of platforms around that. If those are the clients that you're after, or that is an area that you're curious about, please do get in touch. And also on the 10th, Marketing and Miscommunications, how to get the right message across in China, and that is in Beijing. So just to give a snapshot of kind of the breadth of work that we do. More specifically, an awful lot of IP-related things going on at the moment. The IP Roadshow, with the SEO IP Attaché will happen towards the end of October. There will be events in Birmingham, Manchester, London and Cambridge. You can see those there, so please do get in touch if you're interested in attending these events or participating in them. China events right now, Baroness Neville Rolfe, who is the minister responsible for IP-related activities, she's in China this week. There's an awful lot of events going on, including the IP Symposium in Beijing. This morning, CBBC and Alibaba signed an MOU on enforcing IP rights on Taobao and other Alibaba platforms. So there's just loads and loads going on, both in the broad business sense with CBBC and also specifically on upcoming IP-related events. We do have a specific website, which is specific address, which is simply ipr@cbbc.org. That will go straight through to our sector experts who will be happy to help you both here and in China. That's pretty much it for this morning. Thank you very much, everybody, for attending. If you have any feedbacks or suggestions, that could have been about today's session, or you might have a session that you'd like us to do in the future on a specific business area, please do get in touch. Other than that, I would just say thank you very much again to our speakers' time, and I wish you all a great day. Thanks very much. Bye-bye now.